Mr. Venegas, you're charged with racing on a highway. You're facing up to 6 months in jail and or a $2,000 fine. I have previously found probable cause on this case. I'm ordering you now as a condition of your bond not to participate in like-kind activity. If I find that you're racing, reckless driving, acting a fool on the highway, number one, I'm going to revoke.
The judge isn't sugarcoating it. One wrong move, racing, reckless driving, even a hint of acting a fool, and this defendant loses both freedom and driving privileges. No wiggle room. Would you call that tough love or a ticking time?
Bond put you in jail. The second thing is I'm going to take away your privilege to drive. Do you understand?
Yes, Your Honor.
Do you see if he has a license?
Still running it, Your Honor. For some reason, slow.
Mr. Venegas, you are not allowed to drive unless you have a valid Texas driver license and liability insurance. That is also a part of your bond conditions. If I catch you driving and you don't have a license or you don't have insurance, it's not going to go well for you here. Do you understand?
Your Honor.
Okay. You have a lawyer. It is your responsibility to stay in touch with him, and he'll tell you when you have to come back. If he tells me he can't get a hold of you, then I'm going to issue for a warrant for your arrest.
This is a classic courtroom dilemma. Should bond violations mean automatic jail, or do judges need to show flexibility? Drop your take in the comments. Are second chances fair, or do they just invite chaos?
You pick up a new case, act a fool in the free world, I'm going to take it away.
The judge is laying down strict ground rules here. No license, no driving, period. It might sound basic, but many defendants think bond conditions are suggestions, not requirements. Quick poll: if someone violates these terms, should judges give second chances or slam down immediate jail time?
I'm able to run it right now, Your Honor. It's not letting me on our system.
So can you follow the same conditions on the racing that we did?
Same racing conditions, yes, Judge.
All right, so I'm going to have you sign a reset. After that, we'll have you take a seat in the jury box. We'll get your bond conditions. You have to sign it, and after that, you'll be free to go.
Good morning, Your Honor. Good morning. I wanted to approach on behalf of Chaston Blackburn regarding probable cause. I have issues with probable cause in this case, Your Honor.
Okay, let's do it.
So, officers were conducting an unrelated fatal accident investigation when they observed the defendant's vehicle traveling at a high rate of speed towards the blocked portion of the roadway. The officers saw the defendant disregard a barricade and were able to successfully get the defendant to stop by shouting verbal commands and utilizing their flashlights. Upon contact, the officers observed a moderate odor of alcoholic beverage, glassy eyes, watery bloodshot eyes, and slurred speech. The defendant admitted to having 3 drinks at a nearby bar and was temporarily detained. Standard filtered sobriety were conducted. HGN 4 out of 6, walk and strength 4 out of 8, one leg stand 2 out of 4. GICs were read and the defendant consented to breath. The results were .086 and .084.
Your Honor, when you turn on the video and it's between...
But remember, this is probable cause. I don't get access to all that stuff.
I understand that, Your Honor, but when the officer basically decided that he's going to arrest her, basically he puts her in the vehicle, and before any investigation is done, he says, I'm charging her. This is prior to basically any field sobriety test being done. She didn't have any slurred speech, Your Honor. No bloodshot red eyes at all. He said all the buzzwords to trigger probable cause. I'm asking the court to watch.
The defense here is diving into details: bloodshot eyes, slurred speech, timing of sobriety tests. But the judge quickly pulls them back. Why? Because probable cause is a low bar. This isn't trial. It's just, was there enough reason to act?
For 5 minutes, Your Honor.
No. That's in for a suppression hearing. This is a mere probable cause, right? So because I have to give them the ability to respond to your arguments. We can't do that in a probable cause. Like, you know what I mean? So if you're saying it is as it is, see if they'll do a dispositive motion to suppress, where if you win, they'll dismiss, but if you lose, you got to plead, right? Otherwise, we can set it. But when you start getting into the video, when you start getting into the minutia of, well, she really didn't have this, she really didn't have that, I have to give them the ability to respond to that. I can't just rule on it, whether, there was an actual traffic infraction, that's like probable cause or not, right? But when you start getting into the actual details, everything, I mean, that's for, either a suppression or for trial.
That's fair.
So ask them if they're good for, dispositive. That's something that you want to do. Let me see. It's only 60 days old, so you've got some time, I'm happy to do however, go forward with however you want to go forward, but for probable cause purposes, you're getting into argument, right? And I can't give them, I have to give them the ability to respond, Okay, sorry. Okay. Hey, what's up? Hey.
Morning, Your Honor.
Hi, how are you?
I'm here on Miss Villain Ibarra.
The last name.
Ibarra.
Ibarra, okay. What's the word?
So, this first for bond, she has no bond set in this case because she was on no bond for the felonies last time we were here.
Here's where things get messy. The defendant is 6 months pregnant. Her attorney argues compassion, but the court still has to weigh public safety. Should pregnancy ever tilt the scales in bond hearings, or does equal treatment mean zero except?
But the state is unopposed to a PR bond in this case because
She's being held at no bond on the upstairs.
I know, and the felony attorney is working on that. They resolved the felonies on Friday, and the bond was not relitigated up there.
She's going into a PTI. She's going into like a 1-year PTI upstairs. And as part of that deal, we're going to get rid of our misdemeanor, but obviously she needs to get out in order to get into the PTI and everything.
The felony attorney knows about the bond issue. I don't know when she plans to address it, but I'm just here to get her out on the misdemeanor.
This is where courtroom drama gets complicated. The defendant is 6 months pregnant, and her lawyer is pushing for release. Judges have to balance compassion with community safety. Do you think pregnancy should weigh heavily in bond decisions, or should the law treat everyone exactly the same?
Right. Since it's going to be dismissed one way or the other with felony PTI. So I just want to make sure that our case isn't holding up the felony offer essentially.
Is she here now? Do we have her?
She's in the holding cell.
Do you mind bringing her out? I mean, they don't even have a date set upstairs, though.
That's
set for
I know, and
126.
I've spoken to the felony attorney. It was a misstep on her part for sure, but I spoke to the felony attorney and she will go approach on it at some point. I mean,
Are you anticipating a PR bond upstairs, too?
I would assume so, yes, because she has a PTI, like the felonies have been resolved, so I would assume
Never
yes.
assume anything.
I know.
You know?
I know, and I can't speak for what happens in the felonies. I'm only on the misdemeanor, Your Honor, but
And I just see that the agreement's is in deeds and everything, so
Yeah.
it looks like we're moving towards that.
yeah.
I just want to make sure that we don't.
When do you want to set it for? Maybe like a week,
Yeah, that's fine.
and we'll see. Okay.
It's fine.
Does she have history of like flight? Do you know? Because she's got two
Has no
prior.
history of flight. She lived in Houston most of her life. She is pregnant right now. She's 6 months pregnant, and essentially, we just kind of want to
She
get
has
her
two
out.
prior assault cases. Both of those, any flight in respect to those cases?
I'm not. I actually ran over here.
I don't think so. Based on what district clerk shows, no, Your Honor.
Let's take a look. I don't see.
All right, go ahead and sign
So she only has one prior assault. It looks like that one was dismissed. And this new one here, looks like it was charged assault of a hospital personnel, right?
Yeah, that got dismissed on Friday.
Did they refile it as? Okay.
It just got plain dismissed, and then the PTI is for the assault on a public servant, I think. It's a mental health case, Your Honor.
I'm down with you. I'll grant you a PR bond.
Okay, thank you.
The only thing I'm going to ask is that she stays in touch with you, right?
Yes.
I'm not going to continue to do this. Like if she gets out, she just takes off. I'm not going to do it again,
Yeah. Yes.
And I'll admonish her as such. So,
Thank you, Your Honor. I guess she'll still come out, right?
yeah, I need to admonish her.
Yeah.
Who is our CW?
CW.
Hold on a second. We'll get there.
Yeah.
Colin, Tell me, what you got?
I have Sarah Castillo, Judge.
Okay,
That's the one where we were trying to get the records from the sheriff's office. They finally got them to me. And
you have everything you want?
I haven't been able to get through it all. It's like almost 600 pages.
Second, okay. And that is gonna be long. Okay, okay. Lawson, do you speak English, ma'am?
Yes, sir. Yes, Your Honor.
You see, Barr, I want you to understand and appreciate that you have a lot of lawyers that are going to bat for you now, trying to help you even get out. Your lawyer here is asking for a PR bond. You even have the state that's in agreement to get you a PR bond. The only thing that we're asking you to do is...
Protective orders sound powerful on paper. No contact, no threats, no weapons. But here's the uncomfortable truth. They only work if followed. Do you think these orders truly protect victims, or are they just legal speed bumps until something worse happens?
Be safe to our community. Don't pick up any new cases and stay in contact with your lawyer. Right now, I'm going to grant you a PR bond, but I'm not going to do this over and over and over and over and over. I'm going to give you one chance to get out there and do the right thing, make the best of the chance that you're giving. But if you get out there and you just take off and you don't stay in contact with anyone and you pick up a new case, all bets off. Do you understand?
Yes, Your Honor.
I'm not asking for much. All I want is my community to be safe and for you to stay in contact with counsel. That's it. Okay, so I'll grant you the PR bond. Looks like the bond is already set. We're going to set it out for a week because you're still at no bond upstairs, so we don't know what's going to happen in your felony case. So we'll set it off for a week, and then we'll go from there. Okay?
Yes, Your Honor.
Do you have any questions?
Yes, Your Honor.
So tell me about this one here. Who's the complaining witness?
Dating relationship, boyfriend.
Okay. Does he want to have contact with her?
He's not, we haven't.
Strong moment here. The judge issues a protective order, basically a legal shield for the alleged victim. But here's the catch. Protective orders rely on the defendant following the rules. What's your take? Are these orders powerful enough to keep people safe, or just words on paper until they're broken?
He hasn't been cooperative with, so I wouldn't be able to tell you what he wants other than to drop charges, really.
So I want you to understand that I am going to grant what's called a magistrate's order for emergency protection that identifies Mr. Rodriguez as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072, which is the stalking statute. You cannot threaten, harass, use another person to communicate threat or harassing behavior, and you cannot be in possession of a weapon. Do you understand?
Yes, Your Honor.
I'll take off the residential restriction just in case, but everything in the MOAP is stuff she shouldn't do anyways. All right. Understand?
Yes, Your Honor. Thanks.
Judge, I just had a quick question. We're set for trial tomorrow in ERD on a family violence case, and I just wanted to know logistics wise, would we pick tomorrow and then start Wednesday, or if we have a jury tomorrow, do
Are
we
you
just?
really going to go?
Yeah. I mean, it sounds like we're gonna go.
You hear this?
Yes, Your Honor.
I've got 7 other cases set for trial as well tomorrow in here.
Okay.
So let's see which one actually
Yeah, let's see
goes.
what the trial-
So, but technically we pick on a Tuesday, everything starts testimony on a Wednesday, and then we go. That's the way. So, yes, thank you. Mr. Arsenault, you are charged with interference with the emergency request for assistance. You are facing up to a year in jail and or a $4,000 fine. It seems that probable cause has already been found in this case.
Yes, sir, Judge. I don't know why we're here, but,
Because he bonded out.
Oh, yes.
I guess he's been AWOL, right?
no, sir, he's been in custody, Judge. He had a felony, assault of a family member that was dismissed last week,
Okay,
and that's why he got out.
all right. So are there any kind of bond conditions that you guys would like state?
So for this one, just standard conditions be fine with this type of case. And there's no contact for this,
Who's the complaining witness in the,
His mother, Judge.
his mother, judge.
okay. Is that the complaining witness that was in the felony as well?
That's correct, Your Honor.
Okay, so I'm ordering you not to have contact with this person. Do you understand?
Judge, if I may, I provided the state with some information relative to that. The complaining witness in this case is not willing to go forward. She provided a letter to me, which I have already given to the state. She's requesting that the case be dismissed.
The state would not be opposed to no threat.
The judge issues a sharp warning. Another case, another violation, and the hammer drops. Notice how he mixes strict rules with a dash of, I'm not asking for much. It's authority with a side of frustration. Classic judge energy.
Or harassing contract at this time. And just give us another date to reset to look at the 911 phone calls to make sure that.
Okay, so the case is 180 days old. It's time. So we'll give you a week.
Yes, Judge.
So I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case and not to be in possession of weapons. If I find that you violate these conditions, I'm going to revoke your bond, put you in jail. Do you understand? I'm not asking for much. Now, your case is old. It's time to figure out what we're going to do. So I'm going to give the state a week to get everything done, wrapped up. They're going to put an offer on the case. The next time we come back, you must either accept the offer or I'm going to set your case for trial. Do you understand?
Yes, sir.
Okay. So do you mind filing those conditions, please?
Yes, Judge.
All right. We're going to have you sign the conditions. After that, we'll see you in a week. We'll go from there. Okay. Thank you, Mr. D. You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that next time I test you and you test positive, it's just not going to go well for you. Do you understand? We've given you a lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we
call DPS, you know.
Because they're even
you can call DPS. Have I given you the phone number?
I don't think so, did I?
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm going to have you come up here, promise to us that you're not going to drive. Then I'll get you to Victoria Center Reset. You'll get with Felicia if your bond conditions, and after that, you're ready to go. All right, good luck, guys. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
I never admitted that.
All right, ma'am, I'm going to find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just, so what I'm gonna do is I'm gonna have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm gonna find you a lawyer, and then you can explain your side to the lawyer, okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's gonna give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. The officer met with the complainant, the Walmart asset protection employee, and the complainant stated that he reviewed store surveillance, and on September 12, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02, and on September 18, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find your lawyer, ma'am. Ma'am, you were charged with assault. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The defendant, instead of pointing at the complainant, landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
This is the complaining witness to Ms. Price, please.
Your Honor, the complaining witness is her mother of the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of any weapons as well. Did you need a lawyer today? Ma'am? Okay. I'll appoint you a lawyer. For now, I'll have you sign a receipt. Victoria will have you take your seat in the jury box. Do not leave until you sign our bond conditions, and then I'll have you speak to the lawyer here. Okay, please. Okay, ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. And the one-leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were .212 and .217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
Your Honor, we have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Felicia for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, ma'am. Okay. Morning, Mr. Daniels. Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
No, I just started working. I'm gonna give no up. This is the second. I don't have a lawyer next quarter.
I'm willing to give you a free one. Okay, it's up to you. If you have any problems, come back.
I just thought it wasn't so. I'm saying.
Good job, man. Great. What are you doing?
Delivery, so. Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my four list. It's hard finding jobs. It's hard. So I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're gonna go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right, we got you, man.
Thank you.
Good luck. So, ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office, and then you guys can get together with them, okay? So, ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Saldana, I'm going to find that there's probable cause to go forward with your case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target. Do you understand?
Yes, sir.
If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, man. So can you file that, please?
Yes, Judge.
I'm going to have you sign a reset. We'll have you take a seat in the jury box while I get your bond conditions. We'll have you sign it, and after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess, so he's not going to be here. So we'll just do a regular reset. Just do, I guess, 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony, and if not, I will announce not ready, mostly because I got texted some video.